Hello, my name is Cody Price, and I just want to welcome everyone. It is now 1 o'clock, so we'll begin our presentation shortly. Today, on January 27th, we will have a presentation on religion, zoning, and the courts, an overview of RLUIPA, given by um, Dan Dalton. For help during today's webcast, please feel free to type your questions in the chat box found in the webinar toolbar to the right of your screen, or call 1-800-263-6317. For content questions, please feel free to type those in the questions box, and we'll be able to answer those at the end of the presentation during the question and answer session. Here's a list of our participating chapters, divisions, and university. I would like to send a personal thank you to the Michigan chapter for sponsoring today's webcast. So in 2011, we began a change that started on January 1st, where all webcasts will be listed underneath the Ohio chapter. So you'll also be able to see that on the website, to register for these webcasts, they will be listed as either CM approved, or if they don't have anything beside their webcast title as of right now, it has been submitted and it's just waiting on approval. All those webcasts are also underneath a new rating system where they can be rated as either an introductory, advanced, or a live session, and you can find more details about that on the website. Our next webcast will be on February 1st with Planning with Social Media, Tool or Trauma. I want to make a few pointers for new webcasts that were recently added. One on February 17th for Planning for an Aging Population, February 23rd, Developing Aging-Friendly Communities, and on March 11th, Urban Retail. So these webcasts were recently added, so if you're interested in these, please go to www.utah-apa.org/webcast and select your webcast of choice. And also at that webcast, you will find a complete listing for the 2011 webcast series. After the presentation, you will be able to log your CM credits. So to do so, you'll just go to www.planning.org/CM, select activities by date, and then select today's date, Thursday, January 27th, sorry about that, and then select religion, zoning, and the courts, an overview of RLUIPA. And we are recording today's session, and so after today's session, you'll be able to find a PDF and a video recording located at www.utah-apa.org/pastwebcast.htm, and then this should be up over the weekend. I will be going over those details again at the end of the presentation, so if you didn't catch it now, you'll be able to catch it then. So now at this time, I would now like to introduce Amy Jordan, who will be introducing our speaker for today.
Good afternoon. This is Amy Jordan. I am the Education Director for the Michigan chapter of the American Planning Association. We're excited to be broadcasting here live from Ann Arbor. I am going to be introducing our speaker, Dan Dalton. He is the founding member of Dalton, Tomich, and Pensler. He has presented for us before in the past and has had rave reviews. So I'm excited to have him back for us again here today. He has been named one of the 25 leaders in the law for 2010 by Michigan Lawyers Weekly, and he represents religious entities in land use disputes throughout the United States. He received his Bachelor of Arts degree from Western Michigan University and his law degree from the University of Detroit School of Law. Dan serves on the Governing Council of the American Bar Association's State and Local Government Law Section, the Vice Chair of the Land Use Section, and the Chair of the Religious Land Use Committee. He is a life member of the American Bar Foundation and a member of the American Planning Association and the Michigan Association of Planning. Thank you very much, Dan. I'm going to go ahead and turn the stage over to you.
Thank you, Amy, and welcome everyone. It's good to be here. About a year or two ago, I spoke at the National Convention in Minneapolis on a panel on religious land use, and last year spoke to the Michigan chapter at its annual meeting. So it's a real pleasure to be here today. What I'm going to do now, oops, I don't want to do that, is I'm trying to figure out how to make my screen this a full screen, and I can't do that right now. But I have my PowerPoint up, so off we go.
Down on the bottom corner, there is the little logo that's like a full, go up a little bit by the percentage sign on the Zoom. If you click
Okay.
the one on the left side of the Zoom. So go over one more, right there. If you click that, then we'll go full screen.
That's it right there?
Yes.
Okay, we're good?
Yes.
Okay, great. Well, good. Well, religious land use and institutionalized persons. It's a very interesting topic, and you might be wondering, if you haven't worked on this issue before, how did land use and institutionalized persons get together? Well, it has a very long and interesting process, and it basically came down to when Congress was looking at the particular issue of freedom of religion. They decided back in 2000 that the easiest way to get there, to get a federal statute passed unanimously, is to go to two specific issues. One was on land use, and the other one was on institutionalized persons, in terms of giving them the right to practice religion within prisons. But how did we get here, I guess? Yes.
Would you be able to speak up? Some of our attendees are having trouble hearing you.
Okay, not a problem. The question you might have is how did we get here to have this law passed in 2000 that was passed unanimously and signed by President Clinton? Well, let me kind of give you a little bit background about the law, and I'm going to talk a little bit about the constitutional aspects of everything. From there, I'm going to go into the meat of the law, and then I'm going to kind of give you a couple different cases that I've had within the past year or two where we've actually applied the law to different situations. And I've practiced religious land use work all throughout the United States, from California to New York. And I can tell you one thing. Even though you have one statute, it's been interpreted differently in every jurisdiction, not only in every federal district court, circuit court, and court of appeals, but also in the state courts as well. So the very first thing I think you need to take away from this is, before you start analyzing religious land use matters, make sure you talk to local counsel or counsel who's familiar with land use and the RLUIPA, which is the acronym, how it's been interpreted within your jurisdiction. By way of background, in 2000, Congress passed and President Clinton signed the Religious Land Use and Institutionalized Persons Act, and I'm going to call it RLUIPA, and it was designed to provide protection from discrimination for the exercise of religion by incarcerated individuals and those seeking municipal permits or approval in order to exercise their religion. This has had a tremendous impact on land use application and litigation throughout the United States since 2000, and it certainly is not clear yet whether an appropriate solemn-like balance can be developed under the Act to clearly recognize compelling governmental interests in protecting the public health, safety, and welfare through land use planning and local environmental controls remains elusive at this point in time and may depend upon the wisdom of each individual court. How did we get to this law? Well, we start with the First Amendment, and why do we have it? It's because of this. The religion clause of the First Amendment, and there are two. There's the free exercise clause and the establishment clause, simultaneously forbid the government from establishing religion and from prohibiting its free exercise. And both of those clauses are looked upon with great admiration and respect by many. But despite the universal support for the concept of protecting religion, religious controversies make their way into courts in a rich variety of cases, from challenges to the requirement of the Social Security system to attacks on the constitutionality of reciting the Pledge of Allegiance in public schools. Religious claims have also been asserted against drug laws, laws regulating the operation, education, and the prison systems, prohibitions on animal sacrifice, military regulations, and land use and zoning laws.
Dan, I'm sorry to interrupt. Just make sure you're advancing the slides.
Okay, yep.
Thank you.
I'm still in Still in
Oh,
first
he's still
one.
in the first one. Okay, thank
Yeah,
you.
sure. But none of this. Judges have been found to be ill-equipped to examine the breadth and the extent and content of the avowed religion. And when courts are asked to look at the scope of religion clauses, they face really difficult questions. So what happened here? Well, through a series of cases beginning back in the 1900s, Congress said that you can have, with respect to the free exercise clause, which is the one that courts use when evaluating land use cases, with respect to that, you can't impose substantial burdens on the free exercise of religion. Well, what does that mean for a substantial burden on free exercise of religion? Well, the evolution of the clause for a number of different cases, and the biggest evolution that occurred with respect to religion in general occurred in 1963 in a case called Sherbert versus Varner. And in that case, Mrs. Sherbert was a Seventh-day Adventist who lost her job because she refused to work on Saturdays, which was the Sabbath of her faith. And when she applied for unemployment benefits, the state denied them. The Supreme Court analogized this denial to a fine imposed for her Sunday worship and held that no showing merely of rational relationship to some colorable state interests would suffice in this highly sensitive constitutional area. So the court made this test, and this test was a regulation neutral on its face may, in its application, nonetheless offend the constitutional requirement for government neutrality if it unduly burdens the free exercise of religion. The court must not ignore the danger that an exception from a general obligation of citizenship on religious grounds may run afoul of the Establishment Clause, but that danger cannot be allowed to prevent any exception, no matter how vital it may be, to the protection of values promoted by the free exercise of religion. So what does that mean? What that means is that Congress was, or the courts were left with a test that said, hey, you can't do something to state or a private individual that inhibits an individual from worshiping the way that they want. Well, this created kind of a conflict for states and also for federal court litigation. What was it that individuals could do or couldn't do with respect to any point of religious exercise that would not impede on their free exercise of religion? And land use was particularly an issue as well, because there was a sense from some people who read the Sherbert versus Varner decision to say, wait a minute, this says that you can't do anything to inhibit our religion, so I can build wherever I want. And other people said, no, there has to be some sort of reasonableness that comes across this way. Well, from 1963 through 1990, there was a series of cases that kind of evaluated the Sherbert versus Varner test to determine what it would be in particular that would look to, where the courts would look to and say, hey, wait a minute here, this is a situation that does apply or doesn't apply to the evaluation of land use decisions. In 1990, the Supreme Court then issued a decision in a case called Employment Division versus Smith. And in that case, the court said, here what we're going to do is we're going to say any law that is generally neutral in content, if it's neutral in content, then you cannot, there's no free exercise claim. That was a case involving Native Americans using payout in their worship service, and it was out of Oregon. So after Employment Division versus Smith, communities then took the position that, hey, we're applying this law neutrally, generally to everyone. You can't have a religious use here in our town because we're not going to allow any assembly in our town. Or we find that religious use is bad in our town because we lose tax base. Or we'd rather have a Walmart or a car dealership in our town rather than a church because of taxes, or we don't like the religion, or whatever the case may be. In response to that, there was a series of cases, and Congress looked at the issue and passed a law back in 1993 called the Religious Freedom and Restoration Act. And in that case, it was a very broad law that basically preempted the Employment Division versus Smith case. That case, the RFRA, the Religious Freedom and Restoration Act case, or law was challenged in the Supreme Court by a case called City of Bourne versus Flores. And then the court in that case found that RFRA violated Section 5 of the 14th Amendment, the Enforcement Clause, because absent from the statute were any jurisdictional hooks under the Commerce or Spending Clause. So what happened is they said you can't apply RFRA to state claims. You can only apply it to federal claims. So RFRA is still good law right now, but it's only with respect to federal land, not state land. So Congress went back at it, and that was in 1997 when City of Bourne came out. And Congress went back to the drawing board and say, how can we really limit this to make this work? And the first go-around was a statute called the Religious Liberty Protection. And they just were not allowed, and they just couldn't get the support from the people that they needed to get support to get it passed. So then they stripped it down to just land use and institutionalized persons, and that's how, in 2000, RLUIPA, the law was passed. And the law was passed unanimously. Out of all the laws that were in front of President Clinton during his term, this was one of the very few that the House and the Senate passed unanimously, and President Clinton signed right away. And it was supported by a number of groups from both sides of the aisle, conservatives and Democrats. It was Edward Kennedy was a sponsor, and Orrin Hatch was a sponsor, two of the most diametrically opposed political individuals in Washington at the time. And Harry Reid was a sponsor as well. So in 2000, you have this unanimous law that passes that protects land use. So basically what RLUIPA does is it requires that strict scrutiny be used in free exercise cases involving land use regulations and institutionalized persons. So what is the general rule under RLUIPA? Well, RLUIPA has 5 different components to it with respect to land use. There's an institutionalized person section that doesn't apply. But with respect to land use, it has 5 different components. And what it provides under the general rule is what I have on the screen. No government shall impose or implement a land use regulation in a manner that imposes a substantial burden on religious exercise unless the government demonstrates a compelling governmental interest that is the least restrictive means of furthering that interest. Well, what does that mean? Well, as you can see, I've highlighted a number of different terms in there: substantial burden, religious exercise, compelling governmental interest, and least restrictive means. Unfortunately, Congress decided not to define many of these terms. They did define land use regulation, the first part of the general rule, because a land use regulation is defined as a zoning or a landmarking law that or application of such law that limits or restricts a claimant's use or development of land if the claimant has a property interest in the regulated land. So land use regulation is defined. The court or Congress also defined religious exercise. Religious exercise is defined as it includes any exercise of religion, whether or not compelled by or central to a system of religious belief. But what they didn't define is substantial burden under this section. Well, what is substantial burden? What Congress did is they said in Section 2 of the statute that substantial burden is to be decided, or the legislative history says that the term is not intended to be given any broader interpretation than the Supreme Court's articulation of the concept of substantial burden on religious exercise. Well, what does that really mean? Well, that's the question that's been raised the last 10 years since RLUIPA has been in place. Right now, there are generally 4 separate tests of what substantial burden is. And there's one with the Sixth Circuit, which is my test here in Michigan, where they decided not to create a test. They just said, this is kind of what we think it may mean. But it's very difficult to determine what it is because there is no specific test on this ground. In one test of the substantial burden in the Sixth Circuit, the court found that if we give a certain series of factors on religious pressure with respect to this case, then you would have a substantial burden. meaning substantial pressure on an adherent to modify his behavior and to violate his beliefs. Another test under the Seventh Circuit, which is like the Chicago area, what that is that a land use regulation that imposes a substantial burden on religious exercise is one that necessarily bears direct, primary, and fundamental responsibility for rendering religious exercise, including the use of real property for the purpose thereof, within the regulated jurisdictions generally, effectively, and practical. But then 2 years later, after deciding this case, the Seventh Circuit came back and said, no, substantial burden is this. It's the delay, uncertainty, and expense that constitutes a substantial burden. Another test came out of the Ninth Circuit, and the Ninth Circuit substantial burden is an imposition on religious exercise that imposes a significantly great restriction or onus upon such exercise. And the 11th Circuit said that a substantial burden must be more than a mere inconvenience on religious exercise. A substantial burden is akin to significant pressure which directly coerces a religious adherent to conform his or her belief accordingly. So what does that really mean? What that means is that there is no clear definition of substantial burden. Going back to the first key point, if you get involved in a religious land use matter, the very first thing you need to do is look under your state law and your federal law to determine what a substantial burden is. Because even in Michigan, under state courts, the state courts has a different definition of substantial burden than you would find under the Sixth Circuit law for substantial burden. The next thing that needs to be defined is what is a compelling governmental interest. Well, that's been another thing that's been very difficult in these cases. The one trend that we find with substantial burden and also compelling governmental interest is that the facts of the case ultimately control the court's ruling. Again, like I said in Michigan, what substantial burden is a complete and total exclusion of religious activity within the city. So we had a case in front of the Michigan Supreme Court where a church bought a piece of property and wanted to put in senior housing for members of their church, but it would be right on this church property. They could walk to church every day. The church would then have part of its ministry taking care of senior citizens, the whole 9 yards. And in that case, they were denied the use by the local community. In that case, the Michigan Supreme Court said, you know what? You can have senior housing anywhere else in a number of different places within the city, and because it's not totally excluded from this city, it's not a substantial burden. If the case would have been litigated in federal court, then the test would be, does the action of the city or the community place substantial pressure on a claimant that violates religious beliefs or effectively bars the church from using its property? And again, that's something that's something a little bit more than exclusion from a particular piece of property, but something less than total exclusion. So there's somewhere in the middle, and that would be where the facts really control the case. And the same occurs with the compelling governmental interest. Well, what is a compelling governmental interest? That is something that, again, has not been defined by courts unilaterally in these cases. What you can find, though, when you look at compelling governmental interest is that a series of cases are out there that tell you what is or what is not. For example, diminution of value on adjoining real estate has never been held to be a compelling governmental interest, or lack of tax basis has never been found to be compelling governmental interest. Traffic and congestion concerns have not been found to be compelling governmental interest. Parking issues, similarly, have not been embraced as compelling. However, there are certain courts have found in different states have run into different conclusions. Some courts have determined that aesthetic impacts are compelling, and some have found that it's not. Some have found that the preservation of historic buildings are compelling governmental interest, and others have not. There was just a case out of Massachusetts where in Springfield, Massachusetts, where the diocese wanted to close a church in the heart of town and consolidate its members with another church and sell the building. And once that became public knowledge, the city quickly designated the building as a historic building. And in that case, the court came down and said, it's not, the designation of this building is a compelling governmental interest, and therefore the church was precluded from destroying the outside of the building or the inside, taking it apart or whatever the case may be, because of that designation. The same thing occurred down in Peoria, Illinois, I want to say 2 years ago, where in that case the church bought an apartment building, and they wanted to kind of clear out the apartment building and use it for a family life center. And family life centers are usually in larger churches, and it's usually a place where there's a gymnasium, there's places for families to go, like a cooking facility. There might be rooms for rent for like missionaries who come back from overseas or places like that. And this apartment building, what they needed to do is they were trying to renovate it. It wouldn't work, so they wanted to tear it down and build a family life center. And once that became known, the city quickly designated it as historic property and said, no, you can't do that. And the local district court said it is a compelling governmental interest to keep the property the way it is, and therefore, in the Seventh Circuit, the Court of Appeals affirmed it as well. So again, compelling governmental interests are fact-driven in many cases, such as substantial burden. And this slide right here just talks a little bit about what I talked about earlier. There are more approaches to substantial burdens than there are even on these streams as well. And therefore, it's just very important when you're looking at this issue to look at your relevant federal district courts and Court of Appeals, as well as your state law as well. And you might say to yourself, well, why hasn't the Supreme Court taken up the issue yet? Well, it's been in front of them. Most recently, there's a case out of Colorado called Rocky Mountain Church, I believe it is, versus Boulder County. And the issue of defining a standard for substantial burden came up at that point. I represented Living Water Church in the Sixth Circuit on appeal to the Supreme Court. And again, the same issue that was presented to the Supreme Court back in 2008 was, can you please define substantial burden? And there was a case called Petra versus, I think, Willowbrook in the Seventh Circuit back in 2005. And that issue also was teed up right for the Supreme Court to make a decision, just tell us what it is. And the court hasn't done it. So the issue is out there. It's been raised by a number of folks. It's just a situation where the courts the Supreme Court has decided not to decide what a substantial burden is. And these are a couple more examples here on this slide 8 of situations where courts have found when or when not a substantial burden has occurred, or whether there is a compelling interest by a governmental entity in denying the use. There is one clear thing, though, we can all agree about with substantial burdens, and that is religious uses are not immune from land use regulation. And it's very clear in the Act. RLUIPA, as I noted on the screen, does not provide religious institutions with immunity from land use regulations. What this means is that just because you have a church doesn't mean you can go anywhere in a community. And trust me, I represent exclusively religious uses right now. The first 10 years of my career, I represented communities in land use disputes. And I know what the argument is, that because we're a church, we're entitled to it. But the law is very clear, and it's an issue that I discuss with my clients in great detail, that just because we have RLUIPA, it does not mean that it provides a specific immunity or a free pass for a land use regulation. The only situation I had, and I've never had this before, where there was an issue involving the use of land and the religious nature, was a case that I just finished up in the Philadelphia area, or hopefully we'll be finishing up soon. And that involved a piece of land where my clients purchased and wanted to build a Hindu temple. And the guru from India blessed the land and designated it as holy ground. And that created a number of issues with respect to the case. But even with the blessing and the holding ground, it still didn't make it a case that would make it absolutely immune from land use regulation under RLUIPA. Well, let me talk a little briefly about the face of a RLUIPA case, just to kind of give you an idea of how this applies in different situations. And I know all of you have different cases that you're working on right now in different situations, and I hope this one and one following will give you a little idea of issues that are out there. This is a case on this slide from Carlinville, Illinois. Carlinville is a county seat in Illinois, in southern Illinois, about an hour north of St. Louis and about an hour south of Springfield, Illinois. Carlinville Southern Baptist Church is a larger church. They had about 300 to 400 attendees, and what they were presented with was a building that used to be a 60,000 square foot Walmart building, which you can see in the center of your screen. And what Walmart did, and what they're doing across the United States, is that they're taking older buildings that were built in the 60s and 70s, and some even in the 80s, that are 60,000 square foot, closing them down, and then building a super Walmart, usually in the same area, between 80 and 100 or 120,000 square foot, to add grocery stores to it. And what Walmart does, and as well as Kmart and a number of other folks, is they have deed restrictions within their properties. And what they provide is that you cannot use this property for any use that competes with Walmart, and they list all the uses. So basically what it does is it limits the use to churches or to office space. Well, you can't really convert successfully, or I haven't seen it successfully, converting a Walmart or a Kmart standalone 60,000 square foot building to an office. So many across the United States are being converted to churches. And the reason why is they're big buildings. You can easily modify those buildings to a religious use to make an assembly area, and it has the necessary component of parking along with an expansion area that's available to it when the church grows. And in this case, there was and the other thing with this case, with Walmart especially, is that they sell the property very beneficially to religious uses, because one of their core values is to support local churches as well. So my client, after this property sat vacant for about a year and a half, I'm sorry, not vacant, but for sale for about a year and a half, contacted Walmart and asked if they could buy it. They entered into negotiations, and they bought the land. And prior to buying the land, the land was zoned for assembly use, so they could be there. What happens is after the church entered into negotiations with Walmart to buy the land, the city became aware of it. And the city quickly responded by rezoning the land to exclude religious assembly. But they, for whatever reason, allowed secular assembly. In other words, what they did is they said, you can have any assembly you want here. You can have a roller rink, you can have a movie theater, you can have a dance hall, you can have a funeral home, a nursing home, whatever you want, but you cannot have a religious assembly here, which clearly violates RLUIPA. And when the church went ahead and closed on the land, and the city then responded by filing a nuisance suit against the church, saying, hey, what you've done is you've created a nuisance simply because you bought the land. They hadn't started construction yet, as noted in this picture, but they said, we want to stop you from entering, occupying, or using the building. So in response, what we did is we filed a federal court action in Springfield, Illinois, and we sought and we secured a temporary restraining order. And what we did is we went to the court. We showed the history of RLUIPA. We showed what was happening in this case. We went through it and we evaluated the different types of uses that were permitted and showed the court that they specifically targeted my clients to get them out of that building. And as you can see, 8 months later, the case settled. An interesting note out of this case is after we filed suit and did the temporary restraining order, there was a settlement conference, and we went to the settlement conference, and representatives of the insurance company and the city was there, and the mayor was there. And we spent the day, and at the end of the day, we settled the case. So we got the use, we got paid, the whole 9 yards. all it required was city council approval. And that's very typical in these cases. But because members of the council and the mayor were there and we were assured that they were on board, the case would be settled. It went for city council approval. The city council approved, and then the mayor vetoed the approval. We went back to federal court for sanctions, the whole 9 yards. So at the end of the day, we got the use, and it's all good. And at this point in time, the church is very happy, and the community is happy as well. Well, if there was no RLUIPA or no substantial burden, the church would not have won this case simply because the state of the law at that time. Because at that point in time, even if a land use regulation constitutes a substantial burden on religious exercise, it is permissible if it furthers a compelling governmental interest and the least restrictive means. And at that point in time, it was very difficult under the state of law without RLUIPA to prevail. And the question in our case was, how compelling is compelling? In those cases, public safety and health are always raised. In every case, it's always raised. But mere speculation is never compelling. You need specific evidence that a religious use or assembly jeopardizes the city's stated interest. And you have to determine if the religious conduct truly undermines any of the city interests. An example of this is a case that's pending in the Ninth Circuit right now out of Arizona, out of Yuma, Arizona. And in that case, a church bought a JCPenney building that was downtown. And in that situation, it was within a historic zone, and the city of Yuma had created over a series of years a historic community that kind of was right in that particular area. And they excluded religious uses in that area. They allowed other assemblies, but they excluded religious uses. But because they had spent years and years of developing this historic downtown area, that the city said, we cannot allow this here, and the circuit court agreed. Now, that issue is up before the Ninth Circuit right now to determine whether or not that's compelling. But that is one of the cases or one of the situations where the city said, listen, look at all the things that occurred before church bought the land. You know, we created a TIFA district. We collected monies to improve this district. We began our improvements of this district. We did everything we did to create a downtown historic zone, and churches don't fit here. So it'll be really interesting to see what the Ninth Circuit does with that. RLUIPA, one of RLUIPA's also other prongs provides that a city cannot totally exclude a church from its jurisdiction. It's very common to see that, especially in zoning codes where that have been developed years ago, and the communities have gone forward and said, you know, we don't want any churches in our jurisdiction. And there's usually three reasons for that. One is loss of tax basis. The other is they'd rather have a different use where the church is going. Or the third one is just pure religious discrimination. Well, Congress provided that you cannot totally exclude a religious assembly from a jurisdiction or create unreasonable means, you know, within the terms of making the use. And you can't provide what's called, under the Non-Discrimination Act, you can't allow, let's say, one denomination over another. In other words, you can't zone for and allow for a Methodist church but not allow a Catholic church, or vice versa. That occurs as well, for whatever reason. Let's also talk about another example that we just litigated out of Texas, in the central western part of Texas, called the House Where Jesus Shines. This was a ministry of the Church of the Open Door, and what it provided was a halfway house. In other words, a place where individuals coming out of the Department of Corrections for Texas went and they learned life skills, and they got jobs, and they received religious training, the whole 9 yards. And they lived there for a period of 6 months, and then they went on to have productive lives. And the House Where Jesus Shines had an amazing record of getting people through the program without having any type of, without people going back to prison. It was something like 80%, where I think the typical measure of an individual coming out of prison going back to prison was somewhere around 60%. So it was just terrific what the program did. And they had been in existence for 14 years in a very rural area of a county. And they had no incidents with any neighbors or residences or businesses since it started. The Church of the Open Door is located in Waco, Texas. And they became aware of a piece of property in 2006 on a street called Wisconsin Avenue, where it was a former nursing home. So it had wings, it had rooms, it had everything all set up, and it would be perfect for them because the property that the House Where Jesus Shines owned was located about 45 minutes from the church, and where all the classes were, the life skill classes. Like a lot of these guys never had jobs or checking accounts or knew how to buy a car or any of that kind of stuff, or religious training. That all occurred at the church. So you had these folks worked 8 to 10 hours a day. They were bussed in an hour later for classes, then they were bussed back another hour, then had their meals back at the house. So what they thought is, we got this property that's about 1.5 miles away. It'd be perfect for us. Located in a pretty rundown area of town, the city of Belmead, which is adjacent to Waco. It was zoned appropriate for the use. There were some trailer homes, there were some houses. It was kind of a mixture there. And it was zoned industrial, which permitted the use. All the building really needed was paint and minor repairs to get an occupancy permit under the local laws of the building codes. Well, what happened was one of those law of unintended consequences for the church. The House Where Jesus Shines contacted the city building inspector and fire marshal after buying the property, or I'm sorry, prior to buying the property, and said, hey, we're thinking of buying this property for this use. Are you okay with this? And they said, sure. And the city building inspector inspected the property and advised the pastor, his name was Pastor Ronnie Holmes, on how to secure an occupancy permit. And the pastor then visited with the fire marshal to review the occupancy required. And then they went ahead and they bought the land. Well, just less than 10 days later, on December 27th, 2007, a city council member who lived in the general area where this Wisconsin Avenue property was located called the pastor and asked for a meeting to discuss buying the property. And this was right after or near when they bought the property. They then immediately, after they buy the property, they immediately secure electrical permits to repair electrical issues and begin fixing things like repainting or fixing toilets and things like that. The church didn't have a meeting with the city until January because the city administration was essentially shut down between Christmas and New Year's of that year. On December 28, 2007, the church submitted a deposit for water service, and water was turned on by the city. However, a month later, the city turned off the water, locked the system, removed the meter, and made sure that the house couldn't secure water. They even went so far as to dig up the pipe that connected the water from the building to the main water line to make sure that the church couldn't get water in the building. The city manager, his name was Scooter Ratcliffe, directed the city attorney, Charlie Olson, to create a new zoning ordinance that was solely directed to the House Where Jesus Shines, which they admitted during discovery, to basically ban them from the city of Belmead. And it was based on just Scooter Ratcliffe's idea that he didn't want parolees within his city on Wisconsin Avenue. On January 2nd, a sprinkler system company applied for a permit to put a sprinkler system within the property, and the city refused to issue a permit, violating their own ordinances and own laws when they did so. And then the city manager contacted a board member of the House Where Jesus Shines, Mary Threadgill, and inquired if the pastor had the authority to buy the building. And she threatened Mary by saying, you're never going to occupy this building. The church also asked the city hall for a permit to install a new air conditioning units, and the city refused to issue those permits. So what the church did is they contacted the city manager and said, city manager, what is your problem? Why won't you allow us to be here? And the city manager said, the neighbors don't want you there. And they said, okay, well, let's host a program at the Church of the Open Door, and we'll discuss this issue, and we'll see what the issues are. So they host a meeting on January 7th. The entire neighborhood comes. No member of city council appeared at the meeting. The city manager came in, sat for 5 minutes, and then left. The city manager then went to a city council meeting and told the city council that he went to the open door meeting and said that everybody in the neighborhood objected to this use. He then wouldn't allow the pastor to speak during public comments. And during the agenda item for, he allowed the opponents of the House for Jesus to speak, but refused any supporter for the House for Jesus Shines to speak. And then he called an emergency meeting on January 15th, 2008 at 1:30 p.m. without any notice to the city, and asked the city to enact an ordinance. And so they went into closed session. About an hour later, they came out without any debate or input. The city council declared an emergency and enacted the ordinance, which effectively closed down the House for Jesus Shines. And then the following day, the city manager instructed all department heads to implement the ban of the House for Jesus Shines in the city of Belmead. And so the building inspector refused to issue any final permits or inspections for electrical or the work. And again, we talked about the water. By basically, he ripped out had the water line ripped out to make sure that there'd be no water there. We then went to the city to secure what's called exhaustion of remedies to see if we could get any permits to use for any part, use the building in any part in any zoning district, and the city refused to allow this to be placed on the agenda or refused any discussion at all. We then threatened to sue and issued a demand for suit, and the city ignored us as well. So we filed suit in April of 2008. We filed suit under the Religious Land Use Act as well as the Fair Housing Act and asked for a reasonable accommodation to allow its use. The city denied the reasonable accommodation and recommends that the House for Jesus Shines could use its property for any other religious ministry except for the parole ministry. In other words, he said, you can use it, but you couldn't use it for overnight stay. Well, a few months into this case, the state of Texas had a similar case in front of it where the state of Texas invalidated an ordinance that was identical. Basically, the city of Belmead copied that ordinance. But instead of the city conceding and sitting down negotiating, the city refused to repeal the illegal ordinance. Instead, they enacted a revised ordinance, and they didn't give anyone a notice or an opportunity to be heard. They discussed the ordinance in closed session in violation of the Open Meetings Act. They enacted without public participation. They made the ordinance go into effect immediately. And again, it was to ban the House for Jesus Shines from using the using the building for its religious purposes. So we got to trial in September. We went down and got everything ready. On the first day of trial, the judge made some rulings on the different motions in limine, and suggested that the city talk to us about settling the case. And for the very first time on the day of trial, the city saw that there was a significant amount of damages and a very difficult road that they would have in terms of trying the case, because they had the replacement cost of the building, the lost opportunity costs, potential damages for the individuals who are using the facility, and there was also the claim of punitive damages under the Fair Housing Act and RLUIPA. And as a result, the city then went to negotiations, and we were able to settle that case that day. So it was a case where it was from start to finish, took about a year and a half or 2 years, but we were able to get the matter done. So so those are really two significant substantial burden cases that I just kind of want to raise to you, because it's an interesting area, it's fact intensive, and those are the ones that you will be working with the most. The second area that you'll be working with the most is what's called equal terms. And what that provides is that RLUIPA provides that a local government cannot treat a religious use on less than equal terms with similar non-religious uses and from otherwise discriminating on the basis of religion. um, there is no substantial burden requirement under the equal terms use. So what types of uses are equal? Well, this again is case specific, and again, you really do want to talk with with me or with your local attorneys within your jurisdictions to determine what uses are equal, because depending on the state, depending on whatever federal district you're in, something may be equal and something may not be equal. And on this slide 43 that's in front of you right now is a list of cases where generally courts have found to be equal for an equal terms analysis. In other words, a secular assembly use is permitted, but a religious use is not permitted, and these are the equal terms issues. There is a test that most courts look to when they look at equal terms that derived out of the Third Circuit in a case called Lighthouse Institute for Evangelism versus Long Branch. And the test for equal terms is as follows. A plaintiff asserting a claim under the RLUIPA equal terms provision must show, 1, it is a religious assembly or institution, 2, 2, subject to a land use regulation, which 3, treats the religious assembly on less than equal terms with 4, a non-religious assembly or institution, and 5, that causes no lesser harm to the interest the regulation seeks to advance. Again, you really do want to talk to your local counsel to determine what is equal terms or what is not equal terms within your jurisdiction, and the line continues to change, and it will continue to change for a period of time. So you might be thinking to yourself after me talking for an hour on this, why do we have this line, and is it fair and is it constitutional? Well, yes, the issue of constitutionality has been before the U.S. Supreme Court in a case called Cutter versus Wilkinson, and the court has found that it is definitely constitutional. So that issue is off the table. And you're going to be arguing, and many of you, I understand, represent and work with communities, and these are the typical arguments against religious land use applications, that there's no requirement to pay taxes, the depletion of public resources, taking up valuable space or real estate, or simple prejudice against religious denominations. Again, these have never been found to be an appropriate basis to deflate against a particular religious land use. And I would encourage you, there's a series of articles out there right now that talk about the value of religious uses within a community. If you're just talking dollars and cents, there is a significant amount of studies that talk about the value that of dollar-wise what churches bring to a particular community. For example, a fairly extensive study was done in the Philadelphia area about 3 years ago. And in that case, there's a review of a little over 2,000 churches within the greater Philadelphia area. And they determined that each church there provided a sufficient amount of interest and value to the community that came up to something like $20 million a year in value to this community. That is significantly more than any property taxes that are out there. And the argument about depletion of public resources simply does not exist. Churches don't require fire generally, or police generally, or things like that, simply because of the nature of each one. The arguments for religious land use applications is that they really do provide a moral foundation for success as self-government, and our American experience would not succeed without the moral training by churches. And we can debate back and forth whether or not you believe that the Founding Fathers believed in this or had a religious basis for making the Constitution and our form of government. But I really think, and I believe, and I think a lot of scholars also agree with me, that this American experiment would not be successful without this basis of training by churches. So there are a number of social benefits that derive from having churches within your community. It's increased trust, levels of volunteering, things along those lines. So why is RLUIPA needed? Well, why it's needed is simple. It simply levels the playing field. It does not give religious uses an increase or a trump card over local zoning laws. Now, everybody who opposes me in religious land use cases, every professor, every writer out there, and there are many, and many are my friends, will always say that, no, it is a trump card, but it's not. You know, when you litigate these cases, or when I litigate these cases, I know that I have an uphill battle with RLUIPA cases. I know by reading the case law that churches lose more cases than they win using RLUIPA. It's not a trump card. What it is it simply levels the playing field. What it does is it imparts judicial deference to local land use regulators whose highly discretionary decisions compel review. Like the case I just mentioned in Philadelphia a little while ago. In that case, the community simply didn't want a Hindu temple there. It was a older, established, wealthy community that didn't want the Hindu temple. Well, RLUIPA says you can't discriminate against religion based on what type of religion is out there, and that is why we have RLUIPA. Well, 9 years, actually, it's 10 years after RLUIPA. The issue is will the floodgates will open after RLUIPA was passed? Well, it has with respect to institutionalized persons. There are a ton of cases you'll find out there with respect to prisoners who have raised RLUIPA concerns. So if you just Google RLUIPA or do a Lexis search, you'll find a ton of cases out there. And most of those are prisoner cases. In most of those cases, the prisoners lose. But with respect to land use cases, no, there's not that many. You know, I'll be honest with you, I devote a substantial portion of my practice to religious land use throughout the United States. And I may have 30 at most every year total on religious land use matters. So there is not a ton of these cases. The Department of Justice has the ability from RLUIPA to intervene and to raise RLUIPA cases. They've only raised 8 and filed 8 RLUIPA cases in the last 10 years. They've opened investigations in about 54 cases, but only 8 actual litigation cases. With respect to the last point of help from well-funded allies, there are a number of groups that hate RLUIPA, and they have come out against it repeatedly. But every time they do, and every argument that they have on the land use end, they typically use because RLUIPA is constitutional, and it is the right thing to do. So what's next with religious land use? Well, there's going to be a constant definition of substantial burden. I don't think we're going to have a firm definition of that yet. We're going to have to understand what the remedy is. The Supreme Court now has a case of involving RLUIPA on the prisoner side of things, and the question is whether or not damages are available under RLUIPA, because Congress said that in terms of remedy that you're entitled to all appropriate relief, and the question is what does that mean? So hopefully the Supreme Court will say that you are, from my standpoint, or just limit it to prisoners, and then pursuing new cases. The determination of the Obama administration, their focus on RLUIPA cases, seems to remain the same as it was under George W. Bush. Not as involved, but they are still involved. And the involvement of Department of Justice, you'll see them more on cases involving what is now considered the United States minority religion, which is the mosque cases like in the Chicago area or in Tennessee. You'll see cases there. And that is, in a nutshell, where we are at today with RLUIPA. So my hour is up, and I know we have time for questions, so I'll leave that open for Amy.
Okay, I've got the first question that I have is you had mentioned the study done in the Philadelphia area regarding the value provided to the community by churches. Is that something that you could send a link to after the webinar, or is that something that's easily found on the internet?
Yeah, I could send a link to it, or I could. I mean, it was forwarded to me, so I don't know if it would be easily found under the internet. But sure, if you send me your email address, I'd be more than happy to send you the link to that study.
Okay, thank you. The next question I have is can you speak about RLUIPA and the applicability of local sign regulations? For example, are religious uses exempt from temporary sign regulations that promote accessory uses and activities such as daycare, camps, etc.?
Um, well, with signs, RLUIPA does not does not provide any type of immunity for a sign regulation. You still have to comply with the local governmental authorities, regulations and restrictions on signs. There was a case that tested this out of Baltimore, and it was a freestanding sign that was at a building in a location where a number of freeways intersected, and the church wanted to put a sign up and identify the church and have kind of like it's like a flashboard basically up there, and tried to use RLUIPA, but the local court denied that use, and I think the matter's on appeal right now, but nothing really happened with it. So from a sign perspective, general cases have involved state is that RLUIPA doesn't apply. Now, if you had a situation out there where signs are allowed for secular uses, let's say that you have a nursery program at your church, and that there's a private nursery down the road. The private nursery can have 2 signs on its building and a pole sign or a freestanding sign, but the church, but that same use is denied by the church. Then you may have an equal terms type claim, and RLUIPA would apply. But as long as it's not content driven, in other words, the ordinance doesn't say you can never have a religious use on your sign, well, that will be invalidated by a First Amendment challenge. But if it's generally neutral, that all signs are a certain size and a certain number, and you can't have pole signs or whatever, then it's going to be applied generally equal all throughout different types of uses.
Has anyone tried to use equal terms in the opposite? In other words, trying to get a commercial assembly use in a residentially zoned area where churches are allowed?
Not that I'm aware of, because you have to have a religious exercise to use a RLUIPA. So no, I don't think you would be able to do that. But conversely, though, you have the Equal Protection Clause of the 14th Amendment, and you can raise that argument under the Equal Protection Clause. But I'm just not familiar with any cases out there that where folks have done that.
Okay. Thank you. And the next question that I have is, isn't a religious use similar to a bank in what they can take up in property value in terms of retail? Couldn't you prohibit a religious land use in one commercial district and allow it in all the others? So can a government limit churches to some specific zones and prohibit, like for commercial, and then prohibit in others, like residential?
One more time, Amy, I'm sorry.
Yeah, no
Can you say that one more time?
Yep. Is a religious, let's see, could you prohibit a religious land use in one commercial district and allow it in all the others? So I think what they're saying is that could you allow it in residential but not, prohibit in residential but not in commercial? I think, if I understand it correctly.
If you understand. I mean, yes and no. I mean, give me an example. In Carlinville, for example, the ordinance was amended a 3rd time, and after they took out the issue of allowing secular assembly within this particular zone, they amended the ordinance to provide religious use within all residential areas. And in that case, the court, what they basically did is they effectively excluded religious uses within the community. And because there was no collection of residential land that was available to be used for religious use. For example, what happened, and that's kind of a trend right now, I see what the communities are doing, is they said you can have religious uses anywhere within the city except for here. And then you look within those areas, and there's no available land, or the land just is not welcome for building any type of use on it. and for an effective exclusion. So you can't do that. There's constitutional prohibitions as well as case law under RLUIPA that says you can't do that from that perspective. But you can zone areas that say this is where we want religious uses because we have assembly uses here as well. Or like in the Yuma case, which is going to be kind of interesting to see what happens, the Yuma, Arizona case, you can say in that case, well, we have this historic district that we've been planning, we're using, they've been working on this for years and years and years, and from this perspective, what we're going to say is we're only going to have secular assembly uses here, but no religious uses. In that case, and it's very specific to Federal District Court in Arizona, that okay. Other courts have said no. If you're going to allow a secular assembly use, you got to allow a religious use as well.
Okay, thank
Does that
you.
make sense? Okay.
I also had a question about, are churches precluded from following adopted citywide non-residential design standards with this law? And if so, what is the case law?
Case law is all over the board on that one as well. Communities are not precluded from enacting those ordinances, but again, it's got to be clear and it's got to be equal and it's got to be non-offensive to religion. For example, there's a case I have right now in New Mexico where a church, it's in kind of like a downtown area, a downtown zone, and it provides for lighting, like neon type lighting. They want for whatever reason they want to encourage neon type lighting in this area, and that just doesn't fit or work with the church, and the church doesn't believe that it's appropriate based on their religious beliefs to have this requirement to have the neon lighting. And they believe that the only reason that they have this requirement is to make sure that the church doesn't locate in this particular area. That wouldn't be okay. It wouldn't be okay to say that you can't have icons on the outside of your church, for example, because it doesn't fit within the taste of the community. There are First Amendment concerns based on that as well. But you can work through an appropriate design that makes it contiguous or harmonious with the adjacent neighborhood, as long as it doesn't offend religious practices or purposes. In Chicago, there's a series of cases out there right now where there's a prohibition, for example, of placing I think it's called an ERV, E-R-V-E, which is like a Jewish, like a scroll outside a door or outside an area that has a blessing on it. And there's a prohibition on, there was a local community that put a prohibition on that because they didn't want these outside based on design standards. And the court said that violates RLUIPA and also First Amendment concerns as well. So can it be done? Yes. You just have to be sensitive to religious uses, and when you have religious use come in there, the first thing is not to say no, but it's to understand what is the religious need and how can we make this fit specifically or tailor this with our particular ordinance.
Thank you.
Sure.
The next question is, do you have any examples of RLUIPA affecting efforts to control sprawl, especially with the proliferation of exurban megachurches?
No, I don't. I mean, the closest thing I can talk to you about is the Rocky Mountain Christian Church case out of Boulder, Colorado. It is a megachurch. It's a large church. It's in a rural area. The church wanted to expand its campus, and the county in Boulder County had some ordinances that said that you have to limit the type of sizes of buildings in these particular areas for a number of reasons, based on basically the idea was to prevent sprawl. the church's position in that case was it wasn't really to prevent sprawl, but to prevent megachurches or large churches from being there. In that case, there was actually a trial, and the church won a trial. They won it, and they won in the Court of Appeals as well. And that was a case that the Supreme Court denied the use. There's another case I'm representing right now. It's in the Sixth Circuit called Northridge Church. It's a fairly large church out of Plymouth Township, Michigan, and the church was developed under litigation, basically, where they entered into a consent judgment back in the early 90s when RFRA was in place, and the idea was to limit the size of this church in this particular area. And the township enacted zoning ordinances after the church was, or after the case was settled, that basically eliminates any other large church within those areas. The problem with the Northridge case in township's ordinances is that violates RLUIPA and First Amendment concerns as well, because you can't just say we only want these size or types of churches within our area. Free exercise clause allows free exercise of religion, not denomination or size of church, the whole 9 yards. So from that standpoint, the case law is still developing on that particular point, but from that standpoint, it seems to me that the churches have the better argument.
Thank you. The next question I had is, how easy is it to limit church uses to the worship center and prohibit the multitude of accessory uses, such as schools, daycare, arts, theater, bookstores, etc.?
It's an issue that's happening all over the United States right now, and the answer is it depends. It depends where you're at, and depends what the accessory use is. Some courts, like in Michigan, for example, state courts, have determined that religious uses and religious assembly means only that. It only means that uses within a sanctuary, Sunday morning, Wednesday night services, that's it. You can't have bookstores or classrooms for Sunday school or nursery schools or anything like that. Many other courts, many more enlightened courts throughout the United States have said, no, churches are more than Sunday morning and Wednesday nights. It's 7 days a week. It's classes. It's family life issues. It's everything else that churches provide. Angel care ministry, meaning food pantry or clothing or banks or counseling or a number of other things that churches provide that communities don't provide, won't provide, or just can't afford to provide. So the bottom line is you have to really look at your specific jurisdiction to find out how the case law has developed and determine whether it's easy or difficult to limit those particular uses. The one thing I would recommend is if you have a concern about those issues, the best thing to do is just sit down with the church during planning and say, listen, what is it that you want, and how can we make this work within our jurisdiction? Maybe it would be good to have a school or a nursery school there, but not so good to have a homeless shelter or a food pantry or a prison ministry or something along those lines. If you address those concerns with the church outright instead of saying, no, you can't have this, you'll be less likely to find yourself at the receiving end of a lawsuit. But just sitting down, having those negotiations, understanding each other's issues, I think you'll have a better shot of making whatever you want work.
I have another question. Is there a problem with our code if churches require conditional use approval in all zoning districts?
Again, that's more like it is more case law driven on that point. I've argued, and I've been successful in arguing and saying that it is because you don't have church as a right anywhere. You only have it as conditional use, and it's highly discretionary in terms of what the standards are for conditional use or special land use approval. And without having those standards there, that violates both the free exercise clause, the free speech clause, as well as RLUIPA. It depends where you are in the United States in terms of where you're going to come out on that particular issue. And in most cases are not, then yeah, you are going to have a problem based on how the case law is right at this moment by saying you can't have churches except within a conditional uses area. It's kind of like saying that, okay, we'll allow churches in one other zoning district, knowing full well that you can't have a church there at all. For example, finished up a case in a city called Hazel Park, where under their zoning ordinances, they amended the zoning ordinance back in 2005 that says, we wish to exclude, no, it was an ordinance to exclude religious uses throughout city except residential. And then throughout their whereas clauses, they said, whereas we understand that the residential district is 100% built out, meaning you could never build anything there. You could never build a church in that city because there was no parcels, collectible parcels of residential land available to build a religious use, a new religious use, and that case, clearly violates RLUIPA in the First Amendment. So really, just take a look at how your federal courts and state courts have interpreted those provisions under the law.
I have a couple of questions that were related to the Walmart case that you pointed out.
Sure.
What was the city's reason for excluding churches in Walmart?
They wanted to have a retail store there. They just wanted to have they didn't want to have a church there. They wanted to have a tax-paying entity there.
And is it in the case? Is it legal for a city to initiate a rezoning without the owner's permission? What is the relationship between the deed restriction and the zoning?
Yes, I mean the city can initiate rezoning without the permission of the owner. They have to provide notice and an opportunity to be heard, and ultimately they can rezone the land. There's a series of case law out there that talks about if rezoning in bad faith, if that occurs to a church, where they're not, or they're one of those things where the whole idea is just to exclude them. There's a series of cases out there that says you can't do that, but it is okay to rezone without the approval of the owner. With respect to the deed restrictions, that's a completely different story. Deed restrictions don't involve zoning. That just involves a private agreement between the buyer and the seller as to what the use is to be. And you'll see those a lot in Walmart deeds, in Kmart deeds, and the reason why is Walmart doesn't want a Meijer or a Kmart or a Lowe's or somebody that competes with them to go on their old store. So that's why they have those in there. And the challenge with those deed restrictions is Walmarts do everything. I mean, you look at them. There's places to get your hair cut, to get your car worked on, to get eyeglasses, buy groceries, the whole 9 yards. So it's very difficult to have a use that precludes, that doesn't do something that Walmart does. So deed restrictions are a little bit different. It's a little than zoning, and RLUIPA does not apply to deed restrictions. Well, it does apply in some contexts, but it's very difficult.
Another question is, some public agencies have allowed plaques of the Ten Commandments on public property, which special interests have demanded to be removed as a separation of church from state. Are plaques okay or not? Must you allow or prohibit such displays on public property from any and all religions, and is this a RLUIPA issue?
Well, answering the last question first, no, it's not a RLUIPA issue. That issue continues to evolve. There's many Supreme Court cases on that point, the latest of which is called the Sunam decision out of Utah. The crux of that issue is the Establishment Clause, not the Free Exercise Clause. And the Establishment Clause goes to, does this fall within, does this become an establishment of religion by including like the Ten Commandments? There's a very famous case that's ongoing. It's been ongoing now for about 15 years out in the San Diego area involving a cross on top of a hill that was installed years and years ago. And that issue still hasn't been resolved. There's another one involving a cross off of a highway in a federal park. That issue is still not resolved. There's challenges now by groups that have sued cemeteries, like Arlington Cemetery, a number of others, receive crosses or stars of David's on tombstones and crosses throughout. And the claim is that that's an establishment of religion. So those are issues that are still pending right now. I personally don't feel like it is an Establishment Clause issue, but I'm not a judge, so it doesn't really matter what I think. But it's not a RLUIPA or a zoning issue.
Thank you. I was just checking to see a number of questions. I was just checking, make sure most of them were covered. Some of them were fairly lengthy.
No problem.
If a zoning district allows assembly uses, including auditoriums, theaters, dance halls, and gymnasiums, does it also have to follow? Does it also have to allow churches, or can churches be allowed in that zoning district by conditional use permit? It would seem that typical accessory uses and operating characteristics of churches are different than those of assembly uses and could reasonably warrant the scrutiny of the CUP process. I'm assuming CUP is a conditional use permit process.
Conditional use, sure. I mean, again, it depends on where you're at and how the equal terms clause is being interpreted within your jurisdiction. The general rule of thumb, though, is that if you allow a secular assembly use, a gym, for example, then you have to allow religious use. You can't discriminate based on religion. So, with respect to if it's allowed as a right as a secular gym, but conditional use as a church, I think I would have a fairly good equal terms claim there. The one thing that I have to do, though, is before I raise that claim, is I'd have to go through and the Plan Commission or Board of Zoning Appeals or Township Board, whatever the case may be, to exhaust my remedies to determine whether or not the city would allow that use or not. If you just go ahead as a church and go ahead and file suit based on the ordinance, the court would probably dismiss the claim, saying, no, you got to go through the process first to see if the use is permitted or not. But again, there's not a definitive answer to that question. It really depends on the jurisdiction that you're in to determine if there's an equal terms argument or not.
The next question that I have is, if the only land in a city available for a church were prohibited to a church by a deed restriction, would that site be considered available for a church?
If the only land that was permitted is deed restricted, would it be that? Well, that would be essentially an effective exclusion. There is a Supreme Court case called City of Renton, where it involved an adult use. And funny thing in this area of the law is the First Amendment cases involving land use typically involve churches and adult uses, but City of Renton is an adult use matter, and it was kind of the similar argument from the standpoint of, does this effectively exclude the religious use? And the court said it did, and it went through a very thorough analysis based on percentage of available land and what is the definition of available land and things along those lines, finding that even though the use is permitted within the City of Renton, the way the ordinance was designed, it excludes it. On a similar standpoint, I mean, from a pure zoning argument, I have a similar case involving a mine, township zoned particular area in town, saying you can have mining in all these areas except for this one. Well, the one area that they excluded the zoning, excluded mining, is the only area in town where mining, there was rocks and things to mine. In other words, the other areas are underwater or wetlands or forest or residential homes. So that's an effective exclusion as well, and that ordinance will likely be invalidated somewhere down the road. So if it's deed restricted and you know it's deed restricted and that precludes churches, then I think it would be excluded. It would fall within the exclusions and also under the First Amendment concerns and would violate RLUIPA.
Another question that I have is, can a non-religious use sue under RLUIPA if they are excluded but a church is allowed?
Nope. You have to, under RLUIPA, one of the threshold requirements is that you have to be involved within the religious exercise. So if you don't have religious exercise, then the threshold basis for a RLUIPA claim. But you do have a claim under the Constitution, under the Equal Protection Clause or procedural due process or substantive due process or something along those lines, or maybe even exclusionary zoning under state law, but you would not have a RLUIPA claim.
The next question is, with the general expansion of uses within churches, including income-producing uses such as a store, why does this not reduce justification for tax-exempt status? Most other countries levy income taxes on most churches.
Right. Well, it's interesting in these times, at least what I'm finding is that cities are no longer hands-off to church when it comes to religious uses. And what happens and what we find is that if there is an income-generating facility like a bookstore or church right now, I have a television studio, a recording studio, where that is a money-generating income. That portion of the ministry and that portion of the building is no longer considered tax-exempt. And that is okay under the state laws and state constitution and federal laws as well. It's okay to tax those portions. In the broader sense, though, is you'll find most churches are not like that. There's the larger churches or the mega churches constitute less than 5% of all religious uses within the United States. And if you took away that tax exemption for these uses, you would find a lot of churches going away because churches struggle. Churches are having very difficult times right now. They've always had difficult times financially, but now even more based on the economy and where we're at in the scheme of things. So I don't think there is a justification out there to reduce the tax exemption. But if there is an issue out there where churches generating income, then certainly publishing houses, things along those lines, and yeah, I would think that taxes would have to be paid.
So our last question, what is the line between full religious uses and the ones that only incorporate minor religious activities in order to take advantage of RLUIPA?
What is the line? It's really fact-based. It depends on the facts of the case. If it's truly a non-religious use, then RLUIPA is not going to apply. For example, in one case, it's fairly publicized by those opposing RLUIPA, was a group of college students in Washington, D.C. Wanted to live together in a house. The zoning district didn't allow for multiple unrelated occupants in the home. So the students declared their house a church and said, we're exempt, and under RLUIPA, you can't get us out. So at that point in time, the church said, or the area said, we can't go there anymore. So I think my time is up. Thank you for this opportunity, and if you have any other questions, feel free to shoot me an email or give me a call. Thanks.
Yes. Thank you, Dan and Amy, for today's presentation. For those of you still in attendance, Just a little brief recap of logging your SEAM credits. So you'll just need to go to www.planning.org/CM, select activities by date, and then underneath today's date, Thursday, January 27th, you'll find religion, zoning, and the courts, and an overview of RLUIPA. And again, we are recording today's session, and so you'll be able to find a PDF and a video recording of today's webinar at this address. And this should be up by Monday, so be sure to check back then, and thanks again.
Thank you very much.